You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself.
Hey everyone, welcome back to today's video. In this episode, we're heading once again to the state of Kansas, where Judge Webster's courtroom becomes the stage for another round of classic sovereign citizen chaos. What was supposed to be a straightforward legal proceeding quickly turns into a spectacle of confusion, misguided arguments, and courtroom theatrics. The familiar buzzwords and recycled scripts make their inevitable return, with reality once again clashing hard against fantasy. As patience wears thin and facts take center stage, the outcome becomes more predictable by the minute. So buckle up, because this second serving delivers even more disbelief, frustration, and hard lessons from the courtroom.
We will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction, so I had a question about that.
I genuinely don't understand the logic here. If you don't even grasp the nature of the charges being brought against you, why would you ever choose to represent yourself in court? One of the most common misconceptions about the Sixth Amendment, one that we'll be breaking down repeatedly in this video, is the belief that it guarantees your personal understanding of those charges. That simply isn't true. The Sixth Amendment clearly states that you have the right to be informed of the nature and cause of the accusations, not that you will automatically comprehend their full legal meaning. True understanding of criminal charges requires years of legal education and courtroom experience. That exact reality is why the Sixth Amendment also explicitly protects your right to qualified legal representation.
As you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also passed the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that give the court two ways? The Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime?
Take a moment to look around and assess where you actually are. Unless you're standing on a ship in the middle of the ocean, admiralty law has absolutely nothing to do with your case. This isn't some maritime fantasy or legal loophole you can invoke with clever words. What you're facing is an alleged violation of statutory law, handled in a statutory criminal court. that court's authority is firmly established under the 10th and 14th Amendments of the United States Constitution. On top of that, its jurisdiction and procedures are clearly defined and codified by the Supreme Court of Kansas, leaving no room for confusion or imaginary defenses.
Case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under, so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime amnesty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. So when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
therefore,
if
he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury.
We literally encountered this exact same scenario in the case we covered just yesterday. Once again, a sovereign citizen is standing before the court while facing potential jail time. However, the key difference here lies in the maximum possible sentence. Because the total period of incarceration he faces is less than 1 year, the Constitution does not guarantee him the right to a jury trial. This distinction is well established in law and has been upheld repeatedly by the courts. Despite how often this point is misunderstood or deliberately ignored, the legal standard remains clear. And just like before, repeating false claims won't change how the law actually works.
Trial in a Butler County case right before the lunch hour, Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that would that be under? That would be civil? Would
Sir,
that be
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm not understanding, when you say the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I had not asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me please, you need to have them in writing, need to have them filed with the court, you need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells.
Really, Judge Webster, calling that a simple misstatement of the law is far more generous than I'd ever be. In my view, this goes well beyond innocent confusion or minor error. What we're seeing is a harmful mindset that spreads misinformation and undermines basic legal understanding. It moves fast, feeds on ignorance, and gains traction through repetition rather than truth. The problem isn't just wrong ideas, but how aggressively they're pushed as fact. And the more they circulate unchecked, the more damage they do to people who end up believing them.
Yeah, maybe you misunderstood what I was
asking. Please
asking.
don't interrupt to me.
I had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law, and if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Because I was trying to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, then there's someone that's been hurt. So if there's someone to be hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now, that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal. You said it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question, or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. You froze.
I don't know if my phone froze or your deal.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully know how to defend myself.
Okay, now. You don't like my ruling.
You don't. So I have to. So are you telling me I have to get a lawyer to understand? For the record, do you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I shouldn't know about?
Okay, sir. Here's the deal. You're either. I'm not going to play games with you. I understand the sovereign citizen position that you take.
I didn't say anything about sovereign anything, ma'am. I'm asking how the right to defend myself. Under my Sixth Amendment right to know, I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer. And I'm like, before I even go to trial, I like to know what jurisdiction I'm falling up under. And you're telling me how to find, in order to find out, I have to get a lawyer. So you're telling me for the record.
Absolutely, she does. And she's explained it countless times already. At this point, the continued confusion says far more about your refusal to listen than any lack of explanation. This level of misunderstanding fits perfectly with typical sovereign citizen reasoning, especially when it comes to misreading the Sixth Amendment. Nowhere in that amendment does it claim you must already understand the nature of the charges on your own. Instead, it recognizes that legal matters are complex and that understanding often requires professional help. That is exactly why the right to an attorney exists, and your ongoing confusion only proves how much you need one.
You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, because you said it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
But if there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand. Like I'm
If
still not understanding what the whole.
I cannot educate you and train you.
I'm not asking for educate that
If you want to sir, you know there's a person that's going to try to type out this transcript, and if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So, are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try one, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So, what are you going to do on the issue of attorney? Continue to.
I'm just simply asking you to identify which the code of the written law that you're asking to do. I'm just asking you to which code is that you're bringing against me as constitutional law. Because if that's a serious law.
Taking up time. Can you not understand what I'm saying?
Yeah, ask me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a Zoom.
Before we get to trial, I'm trying to figure out the jurisdiction. You just haven't went over to me what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
Yes, I'm appearing in person right now. I'm doing my duty to appear, but you're not telling me.
We're not having a Zoom jury trial.
They're not telling me. You're not telling me you're not even telling me what the nature of the cause. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking, where's the injured party? Can you bring the injured party forward?
Mr. Kervin, you are set for jury trial.
But before we even get to trial, now you still haven't answered my questions. I still want to know the cause of nature of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we get to jury trial. You're just setting it.
You are now found in contempt.
Contempt.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not our attorney. I'm asking you, Judge. I'm asking for legal violation. I asked you what was your legal intent. You still haven't told me what your legal intent. I asked you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that?
The nature of this charge is that you were allegedly operating a motor.
Well, there you have it. You've been informed once again, clearly and on the record. Your constitutional rights have been fully respected and properly upheld by the court. There's no confusion left about what applies and what does not. Now the real concern shifts to your own compliance with the conditions of your bond. If you were released under specific restrictions, traveling out of the state of Kansas without authorization could create serious problems. At this point, you'd better hope you had explicit permission before crossing state lines.
So when I asked you what jurisdiction, the Constitution grants the court the two jurisdictions. Which one is common law, and the other one is
Sir,
maritime admiralty law. You said it's neither one of them.
sir, you
Did
better
not?
go back to law school because I don't think you got the education you need to represent yourself. You either need to go back to law
That's
school
what
or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if
I'm
you're
asking a
not
question,
here
Your
and
Honor.
ready to go, if you're not here and ready to go Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I
And
asked
I
you which
told
law
you, sir, I
only
am
granted
not.
under the Sixth Amendment, right? Under the Sixth Amendment, you have the motion to grant
Okay, I'm
opportunity
gonna
to tell
fine you. I'm only gonna fine you $50 for that first contempt.
$50 for what? What don't
For
understand? Like,
continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me
I'm going to object. It's been asked and
jurisdiction it
answered.
was.
It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case. Where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench. Under the case law, so therefore the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday and move forward in the case.
It really doesn't seem like you thought this through at all. How exactly do you expect to take part in a jury trial in Kansas while you're sitting in Texas? Court proceedings require your physical presence, not excuses or imaginary logistics. This isn't a virtual meeting you can join whenever it's convenient. Jurisdiction, scheduling, and legal obligations don't bend to poor planning. Failing to grasp something this basic shows a serious disconnect from reality. And that lack of foresight is precisely what keeps getting you into trouble.
9 o'clock docket. What do we have going on tomorrow afternoon, Missy?
We have first appearances, and I haven't looked at them yet. And then,
Okay, and then we have 3:30.
yeah, we have a couple at 3:30, and then we have a 4 o'clock case.
Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me in.
I think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have to-
11 o'clock is the perfect time for the state judge.
Well, but I've got to
Does that have to
give
be
Mr.
in court
Curvin.
tomorrow?
I've got to give, sir, please quit interrupting. This is not a free-for-all. Miss Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30, then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot
present.
make it tomorrow, ma'am. I'm in Texas. That's why I was trying to tell you from before.
Well, there's
You told me you said Wednesday at first, and now you're saying tomorrow.
Well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I could
most
do the
cases,
Zoom, but I wouldn't be able to drive because it's like where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like or like probably 2, and I would like drive like this like 32, 14. That's like half the day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like
if you don't have a
I wouldn't.
license, you better not be driving because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option?
When you travel from Texas to Kansas, you pass through exactly 3 states, nothing more, nothing less. There's no hidden jurisdiction, no imaginary boundary, and certainly no special exemption along the way. Geography is not optional, and neither are state lines recognized by law. Whatever personal fantasy you're operating under doesn't magically add another stop to the map. Your so-called state of delusion isn't recognized by any court or constitution. Reality, unlike your arguments, remains fixed and unavoidable.